Welcome. My name is Judge Lenita Skoretz. Over the years, I've taken this class several times. I'm honored that Ms. Adams asked me to make a presentation for this year's Minors Counsel class. I've served as Minors Counsel in family law and guardianship cases for over 20 years. I've been on the bench since December 11, 2023. I'd like to start today with a review of the marriage of Metzger, 224 Cal App 4th 1441. In this case, mother believed that the minor child might be on the autism spectrum. After trial and custody and visitation issues had begun, mother asked for an order to evaluate the child for autism spectrum disorder. The court issued an order to show cause as to why minors counsel should not be appointed. Choosing a proposed counsel, an attorney who had an autistic child, a master's degree in forensic psychology, and experience in dozens of cases involving a child with special needs. Father objected, saying that counsel was biased, but the court responded that they chose this counsel specifically because they were experienced. The findings that I would like to specifically read to you today lay out the authority for the court to appoint minors counsel. A parent's right to control with whom his or her child associates stems from the 14th Amendment's provision that no state shall deprive any person of life, liberty, or property without due process of law. That is from Troxel v. Granville. The substantive component of this due process clause provides heightened protection against government interference with certain fundamental rights and liberty interests, which includes the right of parents to make decisions concerning the care, custody, and control of their children. In addition, there is a presumption that a fit parent will act in the best interest of his or her child. Encompassed within a party's liberty interest in the custody, care, and nurture of a child is the right to determine with whom the child should associate. However, this right is not unlimited. California has recognized situations in which the independent rights of children may provide the state with the need to interfere with the parental liberty interest at issue. For example, it has long been recognized that a trial court has the responsibility to protect the rights of a minor who is a litigant in court. And in this role, the court has the inherent authority to make decisions in the best interest of the child, even if the parent objects. The principle of the best interest of the child is the sine qua non of the family law process governing custody disputes. Although a parent's interest in the care, custody, and companionship of a child is a liberty interest that may not be interfered with in the absence of a compelling state interest, the welfare of a child is a compelling state interest that a state has not only a right but a duty to protect. In fulfilling the duty to protect a child, the court has to follow certain parameters when deciding issues related to the child. And I'm sure that as I go through them, you'll recognize these things because we go back to them repeatedly when determining any issue of custody and visitation. Family Code 3040 says that the court has wide discretion to choose a parenting plan that is in the best interest of the child. We determine the best interest of the child, according to Family Code 3011, by considering the health, safety, and welfare of the child. We also have to consider a history of abuse, but it's upon documented evidence of abuse, the nature and amount of contact with each parent, habitual use of controlled substances, again, upon documented independent evidence of this abuse of controlled substances. The court is required to consider the child's preference if they have the age and capacity to reason and the ability to form an intelligent preference. This is from Family Code 3042. The court also has to consider frequent and continuing contact with both parents and any other factor the court finds relevant in determining what is in the child's best interest or what is impacting their health, their safety, and their welfare. The court may not consider the sex of either parent or prefer a parent as custodian because of the parent's sex or gender, financial resources, employment status. Unless presented with compelling circumstances that separation is in the best interest of the child, siblings should remain together. So, with that background, I want to look at when should the court appoint minors counsel. The California Rules of Court 5.240 subsection A provides the factors that a court has to consider when making an appointment of minors counsel. The court should take into account the following factors, including whether the issues of child custody and visitation are highly contested or protracted. The child is subject to stress as a result of the dispute that might be alleviated by the intervention of counsel representing the child. Counsel representing the child will be likely to provide the court with relevant information not otherwise readily available or likely to be presented. The dispute involves allegations of physical, emotional, or sexual abuse or neglect of the child. It appears that one or both parents are incapable of providing a stable, safe, and secure environment. Counsel is available for appointment who is knowledgeable about the issues being raised regarding the child in the proceeding. The best interests of the child appear to require independent representation, and if there are two or more children, any child would require separate counsel to avoid a conflict of interest. Once appointed, minors counsel is charged with, pursuant to Family Code 3151, subsection A, representation of the child's best interest. Back to the same thing the courts must consider from Family Code 3011, the health, safety, and welfare of a child. The role of the child's counsel is to gather evidence that bears on the best interest of the child. Present that admissible evidence to the court in any manner appropriate for the counsel of a party. If the child so desires, child's counsel shall present the child's wishes to the court. The counsel's duties, unless under the circumstances it is inappropriate to exercise the duty, include interviewing the child, reviewing the court files and all accessible relevant records available to both parties, and making any further investigation as the counsel considers necessary to ascertain evidence relevant to the custody and visitation proceedings. Something that I found extremely useful in representing minor children once I was appointed was to remain neutral as long as possible. I believe this will assist the court because it allows you as counsel to get as much information as possible from both the parents. Once you plant your feet on one side or the other when it comes to parents, you lose the ability to be able to influence, and you lose some of your ability to get information. As in the marriage of Metzger, there's no indication that counsel chose one side or the other in the case. However, you could see a situation where if counsel came down on one side, that might be a basis that father could have objected. Counsel's not listening to me. Counsel's not considering my side, not thinking about what I have to say. So maintaining that neutrality for as long as possible, if possible, going back to where in 3151, where it says that counsel's duties, unless under the circumstances inappropriate to exercise that duty. So you have to use your judgment. But when we discuss the hypotheticals, we'll discuss a situation where it's possible by maintaining neutrality to influence a situation so as not to create deeper rifts between the parents and the child, or the child and one parent, until it becomes absolutely necessary in the best interest of the child, or in other words, for their health, their safety, or their welfare. A second case that I wanted to bring up that does discuss neutrality is the case of A.F. v. Jeffrey F. 79 Calat 5th, 737. This is a 2022 case. In this case, there was a history of domestic violence between mother and father prior to the entry of judgment of dissolution, and when the minor child of the parents was 3 or 4 years old. The judgment included child custody and child visitation orders. When the minor child was 11, the mother, as guardian ad litem for their 11-year-old daughter, retained her attorney from her dissolution to file a domestic violence restraining order on behalf of the child to protect her from her father. Father appealed this on the grounds that the domestic violence was filed really by mother, not by the child, and that mother was using her status as guardian ad litem to put ideas into the mind of the child and to then seek this domestic violence restraining order on behalf of the child. And the fact that she used counsel who represented her in her dissolution was a breach of confidentiality between the child and the mother, and that the child's interests might differ from the mother's, and because the attorney had represented the mother previously, this would be a problem. So I'll let you look up the rulings on all of these matters in the case, because they don't really bear so much on minors' counsel's duties in representing their clients. However, I do want to read you the following statement from the case. A neutral minors' counsel in a dissolution plays an entirely different role than counsel hired in a civil matter. In a family court, counsel for minor has a statutorily imposed duty to present to the court recommendations based on what the attorney believes is in the best interest of the child, in addition to the child's wishes. So this has two different things that we want to think about. One is that the minors' counsel is neutral between the parents. And as stated previously, I think it's important to keep that neutral status as long as possible to gain, so that you can gain as much information as possible before coming down on one side or the other. The other really interesting thing in this case is that minors' counsel has a statutorily imposed duty to present to the court recommendations. Over the years that I've worked as minors' counsel, initially, minors' counsel pretty much gave the court recommendations. And over the years, we have moved away from that to representing minors' counsel, our minors, as we would represent any other client that we have, utilizing our power of subpoena, interview, and then filing paperwork, representing our client at trial. This puts, again, back into the mix, presenting the court recommendations. It would seem to me in this review that it should not making recommendations to the court should not be overused. We need to rely, for the most part, on our ability given by statute to find information, to present that information in the proper format as if we were representing an adult client to the court as far as possible. But then there may be some space in the middle where a recommendation would be appropriate. We're going to talk about some hypotheticals. I'm going to go through some hypotheticals, and then as we go through them, I'd like to talk about different ways, different things you can use in representing your client, where to use them, and maybe how best to use them. So Family Code 3151B then tells us how minors' counsel is to accomplish their representations. Counsel shall serve notice and pleadings on all parties, consistent with the requirements for the parties. Counsel shall not be called as a witness. Counsel may introduce and examine counsel's own witnesses, present arguments to the court concerning the child's welfare, and participate further in the proceedings to the degree necessary to represent the child adequately. It seems to me, despite the statement in AF v. Jeffrey F., that we do all of these things first, found in Family Code 31B, before we make any recommendation. In that sense, the court can rely on the fact that you, as minors counsel, have done your homework. You're presenting evidence to the court, and based on this evidence you're presenting, you have a recommendation. And I would see that as similar to the arguments that we make as counsel. Your Honor, we've presented evidence of all of these things, and therefore we are asking this. So, therefore, in the end, Your Honor, after presenting all this evidence, minors counsel, on behalf of my client, these are the wishes of my child, and these are the things that we are requesting. I'm going to take a moment to present the first hypothetical here. So, you as minors counsel have been appointed to represent an 8-year-old child. This 8-year-old child is suffering from severe depression. In the last years, and his parents have separated several years before, they have a very high conflict divorce. There are allegations of domestic violence made by both parents. They're fighting over every single thing there is to be fought over. They have an 8-year-old child and a 6-year-old child. The 8-year-old child is suffering from this severe depression. They've taken and made the following interventions. He's seen a counselor. They took him enrolled him and participated as parents, at least one of the parents, in an outpatient program for children suffering from depression. And that was every day they went for probably a month at least. During the period of the program, the minor was doing quite well. As soon as the program ended and he was no longer receiving those daily interventions, the minor child slipped back into depression. The parents in court went back and forth, mother filing a request for order that the child be given medication, father objecting to that, and then both parents, who were professionals, spending time seeing the child's psychiatrist, discussing this issue back and forth and back and forth. The mother's position was that the minor child should have medication and it should be given to him as soon as possible. Father's concerned about the effects the medication might have, the stigma that might come with such a young child having medication. And father continued to really not be interested in having their child receive medication. So the court appointed minors counsel. What can minors counsel do? What steps do we take to get to the bottom of this? Do we preserve neutrality? So minors counsel, maybe the first step would be to get your order that specifically waives confidentiality, gives you the right to speak to a psychiatrist, and call the psychiatrist. Talk to the psychiatrist. Perhaps the psychiatrist has a recommendation for you. Maybe at this time, really medication isn't warranted. You could wait. Maybe the psychiatrist would inform you that, no, it's absolutely necessary that this child be placed on medication. That if not, the child is going to continue to go down and down and down, and who knows what the consequence of that will be. Either way, as minors counsel, perhaps you then set up a meeting with the parents, and you say, this is what the psychiatrist told me. What's your position? And you have a discussion with the parents, with their counsel, and you can go through this. If you are neutral in this situation, you have the opportunity to say to the parents, this is what the psychiatrist said. This is what needs to be done. And then I've talked to you, maybe you've talked to the school and sat down with the vice principal and the principal. How's the child doing in school? But if you've maintained your neutrality here, you have the opportunity to convince the parents to come together for the best interest of their child, in interest of his health. Sometimes, and that might work. Maybe you can start there. Maybe you don't yet need. And if that works, that's great. And the parents have now worked together. You can present something to the court and say, you can meet before the court. The parents have been able to work together here. Maybe that will give them one step toward being able to work together. Maybe they refuse. And then as minors counsel, you go back to your right to file and present arguments concerning the child's welfare. And you file a request for order and ask the court to make an order for medication for the child, and you lay out the reasons. Or ask the court to block the parent who is seeking to medicate the child because there are other options and opportunities before you get to a point of medicating this child. We're going to come back to this child. For now, I want to go through the rights that you have as an attorney to obtain information. How do you get the information that you need to sit down with the parents and their counsel and come to a solution if possible? Or if not, to file something before the court. Family Code 3151C gives counsel the rights and lays them out so you have someplace to look if anyone questions you. So it specifically says, child's counsel shall have the following rights. Number 1, reasonable access to the child. So in our hypothetical, you need to be able to talk to the child, not because you're going to make a psychological evaluation or determination, but you need to see the child. Perhaps I would see the child when they're with father, and I would see the child when they're with mother, because they may have a different attitude, a different way of looking at life. It might just be the day, because people who suffer from depression, sometimes they are able to hide that well, but it will still give you information to have access to the child. You have standing to seek affirmative relief on behalf of the child. If the child needs medication, if the parents still refuse to agree, then you have the right to seek affirmative relief. File a request for order. File an emergency request for order if that is necessary to preserve the health and safety of your client. You have the right to notice of any proceeding and all phases of the proceeding, including a request for an examination affecting the child. So if we went back to the marriage of Metzger, which we had the minor child with autism, where the mother was seeking to have an evaluation, minors counsel has a right to notice of that evaluation. If the other parent is seeking an evaluation from a different evaluator because they don't trust the one that mother has chosen, say father in the marriage of Metzger, as minors counsel, you have a right to notice of that examination. You have the right to take any action that is available to a party in the proceeding, including but not limited to filing pleadings, making evidentiary objections, presenting evidence, being heard in the proceeding, which may include but shall not be limited to presenting motions and orders to show cause, and participating in settlement conference, trials, seeking writs, appeals, arbitration. So if you're going to be participate in a settlement conference, some of your positions will be known, but as far as possible, maintain communication with both parents so that if you're in a settlement conference, if you need to speak to them, that you have maintained this communication so that you do not lose the right to influence at settlement conferences. You have the right to access to the child's medical, dental, mental health, and other healthcare records, school records, educational records, the right to interview school personnel, caretakers, healthcare providers, mental health professionals, and others who have assessed the child or provided care to the child. The release of information shall not constitute a waiver of the confidentiality of the reports, files, and any disclosed communications. And you may interview mediators. However, the provisions of Section 31, Family Code Section 3177 and 3182 still apply. You have right to reasonable advance notice of and the right to refuse any physical or psychological examination or evaluation for the purposes of the proceeding, which has not been ordered by the court. So if, as in the marriage, going back to the marriage of Metzger, if you have the child with autism and there's going to be an evaluation, what if the other father decides to have an evaluation, and you as minors counsel, with the experience that minors counsel had, having a child with autism, having a degree in forensic psychology, having a master's degree in forensic psychology, with that experience, if you look at the evaluation that father might wish to put the child through, or mother might have found that she thinks might be appropriate for the child, if with your experience you realize this is not going to be helpful to the child, in fact, there's some aspects of this particular evaluation that might be harmful, you have a right to go to the court and say, you don't have to go to court. You have a right to refuse that that examination or evaluation take place. Now, and you have a right to assert or waive any privilege on behalf of the child. So let's go back to another hypothetical. Let's talk about a minor child a girl this time, who is 11. She's been acting out violently in one of her parents' home. In this case, mother's home. She's been acting out violently. She has an older sister and a younger brother. And at home, mother will describe to you that the minor child at home will destroy a basket of clean clothes, cover them with detergent again. She will go into her older sister's room, destroy her belongings, pour detergent over her clothes, take them out of their drawers, throw them all over. There are other places in the home she'll do things that are violent and destructive. She hits her sister, she hits her mother. She's completely oblivious and unaffected by any type of normal and usual punishment. Let's say allowable discipline. That's a better way to put that. When she's at father's house, or father claims, this doesn't happen at my house. There is no problem with her at my house. The problem is getting so bad that mother's ready to turn custody over to father, and the parents can't agree. Should we even have her evaluated? Should she even be in counseling? And father is opposed to any type of counseling for his minor children. So you talk to the parents a little more. So it turns out that a couple of years before, there was when the child was at father's house, in father's care and custody, and in father's care and custody, the child is often left with her paternal grandmother and extended family. A member of father's extended family, one of her cousins, accused her of some inappropriate behavior, sexual behavior, touching something. And no one really stood up for her. She said, absolutely not, I didn't do this. The matter was never further investigated. There was never a CPS report. It just simmered, and there it was. And now, in 2000, when the child is 11, she's acting out. So you're appointed as minors counsel. What actions are you going to take? You would talk to the mother, you would talk to father, I would think that you would want to go to the school, find out if there's something going on. You have the right to speak to people at school. And then you would want to probably, of course, you would talk to your client and see what she has to say. She may say to you that she doesn't understand what's going on with her. She may tell you how much she doesn't like her mother or she doesn't like her father. I don't know what she might say to you. But once you get all your information together, perhaps the first thing that you could do is to seek affirmative relief on her behalf, to request that she be allowed to see a therapist. And I'm going to bring in here, as with the previous case, that the law in California is changing regarding who can consent to mental health treatment. Up until July of this year, a minor who is 12 years of age or older may consent to mental health treatment or counseling on an outpatient basis, or to residential shelter services, if both of the following requirements are satisfied. The minor, in the opinion of the attending professional person, is mature enough to participate intelligently in the outpatient services or residential shelter services. And number 2, the minor would present a danger of serious physical or mental harm to self or to others without mental health treatment or counseling or residential shelter services. Or B, the child is the alleged victim of incest or child abuse. Beginning in July 1 of this year, this code section changes, and this is Family Code Section 6924B. It now reads, a minor who is 12 years of age or older may consent to mental health treatment or counseling on an outpatient basis or to residential shelter services if the minor, in the opinion of the attending professional person, is mature enough to participate intelligently in the outpatient service or residential shelter services. So I think now you have 3 options to care for your child. You can talk to mother and father, maybe get them to agree that the child begin to see a professional. At some point, even if one of the parents disagrees, if this is being helpful to the minor child, when they turn 12, now they are able to consent to that treatment themselves and to go forward with the treatment. And you, as their advocate, have the right to be sure that they are put in a situation that they know that they can consent to that treatment and they can seek the help they need. If either parent puts a roadblock in the way, then you have the right to seek affirmative relief on their behalf. So children, these are the first places when it comes to mental health. There are other statutes that go to mental health, to medical health, different things that now are starting to put ages to. At this age, children do have some rights on their own, absent their parents, to seek this relief. So California Rules of Court 542, I, J, and K discuss the rights of counsel for the child. This is in addition to Family Code 3151, and I think it lays it out in some sense even more explicitly. You have reasonable access to the child. You can seek affirmative relief on behalf of the child. You have a right to notice of all proceedings and all phases of that proceeding, including requests for examination affecting the child. You can take any action available to a party to the proceeding, including filing pleadings, making evidentiary objections, and presenting evidence. You have a right to be heard in the proceeding, which may include presenting motions and orders to show cause and participating in settlement conferences, trials, seeking writs, appeals, and arbitration. You have right to access the child's medical, dental, mental health, and other healthcare records, and school and educational records. According to this rule of court, you have the right to inspect juvenile case files, subject to provisions of the Welfare and Institutions Code. You can interview school personnel, caretakers, healthcare providers, mental health professionals, and others who have assessed the child or provided care. However, the release of this information to counsel does not constitute a waiver. You have a right to interview mediators, subject to the provisions of the Family Code. You have a right to receive reasonable advance notice of and to receive a physical or psychological examination or evaluation for the purpose of the proceeding that has not been ordered by the court. And perhaps think of a case where your client is going through gender dysphoria and one parent is very opposed. They might wish to try to seek treatment that would undermine the child rather than support them in decision making. You have a right to advance notice of that treatment and to to then waive or assert a privilege on the behalf of your client so that they won't have to do that. You can seek independent psychological or physical exam of the child for the purposes of the proceedings and approval by the court, receive child custody evaluation reports, not be called as a witness, request the court to authorize release of relevant reports or files concerning the child represented by counsel of the relevant local child protective service agency, and receive reasonable compensation and expenses for representing the child. So those are your rights. And in family law, I'm sure in every aspect of law, with rights come responsibilities. So you want to also be aware of what your responsibilities are and think about those as you think about representation of the child. So your responsibilities are found in California Rules of Court 542J. You're charged with the representative of the child's best interest. The role of child's counsel is to gather evidence that bears on the best interest of the child and present that admissible evidence to the court in any manner appropriate for the counsel of a party. If the child so desires, the child's counsel must present the child's wishes to the court. So your duties include these: interviewing the child, keep going back to that one, reviewing the court's files and accessible relevant records, making any further investigation that counsel considers necessary to ascertain the facts relevant to custody or visitation hearing. You must serve notice and pleadings on all party. You may introduce, examine witnesses, present arguments to the court concerning the child's welfare, and participate in the proceedings to the degree necessary to represent the child adequately. In any case in which counsel is representing a child who is called to testify in the proceedings, the counsel must provide to the child in an age-appropriate manner about the limitations on confidentiality and possibility that information provided to the court may be on the record and provided to the parties in the cases. Allow but not require the child to state a preference regarding custody or visitation in an age-appropriate manner. Provide information about the process by which the court will make a decision. Provide procedures relevant to the child's participation. And if appropriate, provide an orientation to the courtroom where the child will be testifying. Inform the parties, other professionals serving on the case, and the judicial officer about your client's desire to provide input and address the court. And if so informed by the child at any point, provide notice that the child has changed their choice about addressing the court. Notice must be provided as soon as feasible to the parties or their attorneys, other professionals serving the case, and then to the judicial officer. So at this time, in the last several years, and I have had before me, just as in the case of AF v. Jeffrey F., a minor child who has filed a request for a domestic violence restraining order against their parent. Family Code 6229 states that minors age 12 can initiate domestic violence pleadings against a parent. So in that case, the court has the option of appointing an attorney to represent the minor child or a guardian ad litem to represent the minor child. And it might be a good idea in this case to, as it says in court rules of court, to explain to your client their rights and responsibilities, that they will have to be testifying in this case. They'll have to testify in front of the parent that they are requesting a domestic violence restraining order to protect them from that parent. You might want to take the child to the courtroom, as it says, orient them, show them where they will sit, what they will have to say, where they will be testifying from, who will be listening, and then if they have worries and concerns, you could present those worries and concerns to the court. And the court may decide to meet with the child briefly to say hello, say that they'll be there, they'll be listening. They will protect that child as far as possible from aggressive or argumentative cross-examination, and within the rules of evidence, they will do that. So that if your client is going to proceed with the domestic violence restraining order, that they will be as comfortable as possible when that proceeding begins. So now I'm going to go back. I want to look further. I'm going to read Section K of California Rules of Court, because this is other considerations. So it's just a few added things that are thrown in. So to be sure that counsel is not required to assume the responsibilities of a social worker, probation officer, child custody evaluator, mediator, and is not expected to provide non-legal services to the child. Subject to the terms of the court's order of appointment, the counsel for a child may take the following actions to implement his or her statutory duties in representing a child in a proceeding. So some of these are going to be similar and start to sound really familiar, but some of them are a little different. You are to interview or observe the child as appropriate to the age and circumstances of the child. In so doing, counsel should consider all possible interview or observation environments. Select a location most conducive to both conducting a meaningful interview of the child and investigating the issues relevant to the case at that time. Just in reviewing that and thinking of my experience, you might want to visit your client at home. You might want to have a place set up in your office that has age-appropriate toys, drawings, different things, so that you can make your client comfortable prior to the conversation. You might wish to interview or meet with a child with their counselor present. You have to think about why you've been appointed and what is appropriate to their age. You also must, to the extent consistent with the child's age level, maturity, and ability to understand, explain to the child at your first meeting counsel's role and the nature of the attorney-client privilege, including confidentiality. So, what you can talk to me. I will keep all of your secrets, but I'm going to ask you, because sometimes I might have to say something about this. Ask your client, what is it okay to talk about with anyone else? Do you have a limit? Maybe not use the word limit, but go through this carefully. Is it okay? You've told me this about your mom. Is it okay if I say this to the judge or someone else? Will this worry you if I tell your mother this, or I tell your father this? And as far, knowing their age, your clients will tell you, no, don't say this. I'm telling you this, but please don't say this. So as far as possible, then you have to honor that within your duties of confidentiality to your client. And then also, interestingly, you are to advise the child on a continuing basis of possible courses of action and of the risks and benefits of each course of action. We'd really like to get you into counseling. Your dad's upset about this, or your mom's upset about this, but this is what's really good for you. I've had an occasion to have a minor child tell me, I need to be in counseling. I'm doing really well in counseling. My dad doesn't like that. My counselor and I are talking about appropriate boundaries. And this boundary is one that my dad keeps crossing. As long as he crosses that, I don't want to see him. She was 12. So her counselor was doing a really good job at helping her to understand, making my job easier in going through what if this happens or this happens, this is a risk of making this decision or not. So this also says that you must actively participate in the representation of the child at hearings that affect custody and visitation of the child, and attend and participate in any other hearings relevant to the child. In doing so, counsel may, as appropriate, take positions relevant to the child on legal issues before the court. Seek and advocate for services for the child. Prepare for any hearings or trials. Work to settle contested issues and to define trial issues. Here's a spot where you are working again with both parents, counsel, to try to get to resolve contested issues. Prepare witnesses, including the child, if the child is to testify. Introduce and examine witnesses. Cross-examine other witnesses. Make appropriate evidentiary objections. Review court files. Prepare motions to advance the child's interest. Present arguments to advance the child's interest. Prepare trial briefs and other documents. Request appointment of separate appellate counsel. Conduct thorough and continuing and independent investigations and discovery to protect the child's interest. This may include obtaining necessary authorization for the release of information, reviewing the child's social services, mental health, drug, alcohol, medical, law enforcement, education, and other records, reviewing court files of the child and his or her siblings, case-related records of social services agency, case-related records of other service providers, contact attorneys for the parties and non-lawyer guardians ad litem, court-appointed special advocates and other service professionals to the extent permitted by local law for background information, contacting and meeting with the child's parents, legal guardians, caretakers, and with the permission of their attorneys, interviewing witnesses and individuals involved with the child, including school personnel, child welfare caseworkers, foster parents, other caretakers, neighbors, relatives, coaches, clergies, mental health professionals, physicians, law enforcement officers, and other potential witnesses. Review relevant photographs, video or audio recordings, documenting the results of these investigations. Monitor compliance with court orders, including the provision for and effectiveness of court-ordered services. Promoting the timely progression of the case through the judicial system, investigating the interests of the child beyond the scope of the proceedings, and reporting to the court other interests of the child that may need to be protected by the institution of other administrative or judicial proceedings. However, counsel is not responsible for instituting these proceedings or representing the child in them unless expressly appointed by the court for that purpose. After learning of existing administrative or judicial proceedings involving the child, communicating and cooperating with others to the extent necessary and appropriate to protect the child's interest, taking all other steps to represent the child adequately as appropriate to the case, including becoming knowledgeable in other areas affecting the minors, including the Indian Child Welfare Act, information about local experts who can provide evaluation, consultation, testimony, delinquency, dependent, probate, family law, and other proceedings. So let's go back for a few moments to our hypothetical. Let's talk about the child who was 8. Now, the child is 13. And in addition to having he's been on medication for his depression for 4 years. At the same time as he was suffering from depression, he was also suffering from ADHD. And there were interventions being attempted. He has had plenty of time with a psychologist. He's still suffering. And psychiatrist is recommending prescription medication for his ADHD. And there's still, again, in this situation, one parent blocking treatment or delaying treatment by asking questions. But now you have a child who's 13. This child does have some right to consent to medical treatment or mental health care treatment. And you also may now have discovered that you have one parent who is manipulating the child. So you have maybe one parent who seems to you to be wanting to control every aspect of a child's life, to go through and effectively have a time for everything, a place for everything, in an attempt to help their child deal with the ADHD, in addition to taking medications. And you may have another parent who has a completely different approach, and that is, well, we don't want to stigmatize. We don't want, we don't want to have to be taking medications. Maybe they have side effects that aren't going to be that great. And the child identifies with the parent who doesn't want to deal with this through medication and is very angry with the other parent who now is trying to control many aspects of their life. And yet, so then what do you do? How do you approach this? It seems to me that in this case, you need to utilize every one of the things that you have available to you to gain information, to try to help this child to be able to navigate the situation in front of them for their health and their welfare, and ultimately their safety when it comes to the issues of depression. ADD, their welfare; ADHD, their welfare, because they need to be able to learn the tools whatever tools they can to deal with ADHD, to understand the condition, as well as probably take some medication. This is a very difficult issue with these highly conflicted parents. What about, here's another situation. You have a minor child, age 16, mildly developmentally delayed. For the last 4 years, she's lived mostly with her father, but she suffers from severe heart disease. She may soon need a transplant. The parents are separated. Mom has been absent, and the claim of mother is she's absent because father was violent, and she finally just had to leave the situation, leaving her minor children with their father. So now this child is suffering, might need a heart transplant. They're working with a local medical institution to help them be able to get that transplant. But getting a transplant isn't as simple as walking into the hospital and saying, wow, I'm not doing well, give me a new heart. There's a whole process that comes before. So most places do not give transplants to people who are developmentally delayed at all. Because not only is there a process before, there's a process after. And you have to be able to follow through with that. You have to be able to do each thing exactly when it's supposed to be done. Failing your medication for 12 hours can cause your body to begin to reject your new heart. So all of those things have to be regular. It has to be done all the time. Coming up to this, the hospital has a social worker, and they evaluate everything that is necessary. They look at the family structure, the families from the mother's house and the father's house, the ability of the patient. They go through all of these things. And mother comes to court and says, please help me. Give me custody of my 16-year-old child, because if you don't, she will be kicked off the transplant list and she will die. And the court looks at you and says, counsel, I need more information here. Will you please, I'm going to appoint you to represent this minor child, and I need you to come back in 2 weeks and tell me what's going on here so that I can make the best decision possible for the health and safety of this child. So, and here's the name of the social worker, and otherwise, here's the father's name and phone number, here's mother's name and phone number. You go for it. So here's a space where talking to the social worker is probably your best bet. But you also have the right to talk to the doctor if you can get a hold of the doctor. To other mental health other health professionals that might have interacted with father. The child has been in father's custody. Why are we going to be kicked off the transplant list? What's going on? Talk to father. Well, this is a big decision. If she has that transplant, she could die. But this situation, he sees it now, is fairly controlled. She's not in the hospital yet. She's still able to function. Not at 100%, but she's still functioning in her daily life. She could go to school. And here you're trying to put her on this list, and you're going to change out her heart. And I don't think it's ready for that. And so he's not been cooperative with the process. not understanding that the process, you have to cooperate with them all the way along. Maybe mom hasn't really seen her, but except for weekends, but mom is really on board with this process and understands a little better. You as minors counsel have to use all those things that we've been discussing to help you find a solution and to be able to go back to the court and give a report that says, these are all the things I found. And in this space, a recommendation is probably something the court's looking for. Yes, I found out that if they follow the process, this institution will do the transplant for this minor child when it becomes necessary. But all of this lead up has to come first, and they have to cooperate. And the only person that's going to do that is mom, because dad doesn't understand. So yes, the court should, for the safety and welfare of this child and her health, change custody today. There's your recommendation based on all the information that you've been able to learn about what's going on with this child. Here's another situation. You have a minor, age 16. She and her older sister were left at the care and custody of their father when they were 10 and 12. Their parents had a very high conflict divorce. There were allegations of domestic violence. And finally, mother left, moved out of state, leaving the kids with their father. At this point, the older sister has turned 18. As soon as she turned 18, she left the house, leaving the 16-year-old with father. The 16-year-old has gotten in touch with her mother and said, get me out of here, basically. And mother has filed something with the court. The court looks at that and says, I need minors counsel to find out what's going on here. You're appointed. You talk to your client and you find out that your client tells you, my dad is keeping me isolated. He changed my school. He moved me away from where I used to go to school. He will not allow me to talk to my sister because the fact that my sister moved in with his sister, who he had a fight with, means she's taken a side against him. He won't allow me to talk to her. As soon as I go home, he takes my cell phone. So I have no way to call my mother. I can't really talk to my friends. And on top of that, several years ago, a year or so ago, he took me to Mexico, and while there, one of his relatives sexually abused me. I told him that, and he told me I was asking for it. I need to be out of here. If I'm not out of here, something terrible is going to happen. I have to leave. I can't stay here. So in that case, it seems to me that that's a case where you don't try to talk to the parents. You have a 16-year-old, get her out of there. You file your request for order. You tell the court what the problem is, and you ask the child be moved so that the child can have contact with her sister. Ideally, somebody would file the aunt where the sister's living could file a guardianship action, but that would take much longer. And your client has told you that the situation is dire and she needs help now. So sometimes that's just it. Your client needs help now, you help them now. You have other situations like your children who need therapy or need evaluation, or we need to figure out why are they being violent in one parent's home. Those require a lot more investigation and time and talking to people and getting your client in therapy and sticking with the case. You should also always remember that the judge has a couple of tools also. If parents, child, someone says to you, well, CPS was called on that parent, and you need to know about that before you can file something. Remember that the court has the ability to request from Family Court Services that they do a collateral investigation. And as part of that, they can contact CFS, CPS, and find out, are there any investigations? If there were in the past, what was the finding of these different complaints and investigations? That can give you a picture to start with and a picture to look at. And then you can use that to try to find other information that will be helpful to your client. Another thing that a court can do is request an investigation under Family Code 3027 into incidents of physical and sexual abuse. It's not done often, but it can be extremely helpful when you have parents who are on opposite sides and you have a child in the middle. If you can request that the court ask for one of those investigations. It will give you a starting place, and you may then need to get other records and things to prove your case. Most cases are difficult, complicated, and take time. And I can tell you that the court appreciates very much the time that you spend working on representing your client efficiently and well, because oftentimes information is what courts, well, not oftentimes. In my short tenure on the bench so far, I have discovered that information is desperately needed in many cases, because you have children in the middle. You can see that there's a high conflict, and you have one side and the other side each saying something different. Family Court Services does a great service for us in providing information and sitting down, spending more time talking to the parents and trying to help them come together to find a solution. Minors Counsel, on behalf of the children, can serve that same function. You sit down, you talk to the parents, you find more information. The more information that you have as Minors Counsel, that Minors Counsel can provide to the court, the better and easier it is for the court to determine what is in the best interest of the minor children, because that, above all, is the duty of the court. The children are not property of their parents, even though their parents do have a 14th Amendment interest in them. And the public policy is that, like the Metzger case, that it's the children that are our focus. It's providing for their health, their safety, their welfare when it comes to making child custody and child visitation orders. So there are these situations that, for all different reasons, have become more and more complicated. And when Minors Counsel is appointed, we greatly appreciate your willingness to serve and look forward to the information that you can collect and provide to us on behalf of your clients. And the Family Code and the California Rules of Courts lay out all of the things that you can do and the rights you have to work to represent your children. It would be really nice if I could take questions now. And in another forum, at another time, we may be able to have further discussions about this and about ways to accomplish the goals that you have as Minors Counsel. At this point, however, I thank you for your attention and for listening, and I hope that I've been able to help you see the representation of Minors Counsel and the importance of that job from the court's perspective. Thank you.